The broadcast is now starting. All attendees are in listen-only mode.
Welcome to the webinar, a brief guide to getting and keeping your clients with foreign connections out of trouble, including FBARs, OVDP, and lesser-known issues. Before I introduce Dennis Brager, let me cover a few items. A recording of the webinar and the PowerPoint will be posted on the website. And please type your questions into the chat box in the panel or the question box. The Brager Tax Law Group provides continuing education for CPAs and enrolled agents, and an application requesting MCLE credit for attorneys for this activity is pending approval by the State Bar of California. So please make sure that you've signed into the webinar with your first name, your last name, and your email address, because this is our electronic record that you've attended. And if you plan to receive CE credit, please email Giovanna, and you can see her email address on the screen here, for your webinar evaluation form and certificate. Let me introduce Dennis Brager. Dennis is a California State Bar Certified Tax Specialist and a former senior tax attorney for the Internal Revenue Service's Office of Chief Counsel. He is a regular speaker at the UCLA Tax Controversy Institute and has advised hundreds of clients with unreported offshore accounts. He has been quoted as a tax expert by Business Week, Accounting Today, the Daily Journal, the National Law Journal, the Daily Beast, USA Today, Palm Beach Daily News, Money Laundering, the Los Angeles Daily Journal, and Tax Analyst. Dennis has been a guest on ABC Television's Good Morning America, Fox Business News, TV One Access, and KFWB Money 101. Welcome, Dennis.
Thank you, Barbara. And good morning to all of you, and good afternoon to those of you on the right coast who are listening in today. I'm going to start off by talking very briefly about the problem. I think most of you already know what the problem is. U.S. persons that have the authority to sign on an account or have a financial interest in an offshore account have to file the FBAR, the Form FinCEN 114. That used to be a TDF 90-22.1, but the form number has changed, along with the method of filing it, which is now restricted to electronic filing. Of course, in order to understand who has to file, you need to know who a U.S. person is. Generally speaking, that's a U.S. citizen or a U.S. resident. I'd like to point out here that because effective with the new FinCEN regulations, they're not so new anymore, they went into effect on March 28, 2011, but as of that point, the substantial presence test, the 183 days in the United States test that you may be familiar with under Section 7701B, causes somebody to be a U.S. person if they're here for that period of time. So even someone here on a work visa who is not a U.S. citizen and is not a green card holder could wind up with an FBAR filing requirement. As I mentioned, anyone with a financial interest in the account must file an FBAR. So the question becomes exactly what is a financial interest? I'm not going to go through this in any great detail. Again, I think this is these are items which are generally understood, but I do want to highlight subparagraph B here, and this points out that a person who owns more than a 50% interest directly or indirectly in another entity or in an entity, and if that entity itself has a foreign bank account, then not only does the corporation have to file an FBAR, but the individual owner of the corporation, of more than a 50% interest in the corporation, needs to file an FBAR. And I was having a conversation just yesterday with a business manager, and the question came up that his client owned more than 50% of a foreign entity, which in turn owned multiple layers of additional entities. They were all wholly owned subsidiaries. And as you went down through the various levels, at the bottom and at varying points along the chain, there was a foreign bank account. And because the U.S. person owned had a more than 50% indirect ownership in the bottom layer entities, and those bottom layer entities had foreign accounts, the U.S. person at the top of the chain and any additional U.S. persons in the chain are required to file FBARs. And you can definitely have situations where multiple FBARs are being filed for the same account. That's not at all unusual. Well, we've all seen this Schedule B question numerous times, so I'm not going to waste time by going over it.
Dennis?
But yes.
Dennis? Yeah, we did have a question come in, and I just wanted to pop in and ask you, do you attribute the spouse's interest to a U.S. shareholder?
All right, do you attribute the spouse's interest? No, generally speaking, you look at each person's separate interest in the account. And so, for example, you don't take community property interests into account. It's each, you look at each spouse separately. So, for example, we had a situation where our client, the wife, owned 50% of a foreign entity, and the husband owned 50% of the foreign entity, and the question was whether or not either of them needed to file an FBAR based solely on their ownership interest in the foreign entity, and the answer was no. Now, if either of them is a signer on the corporate account or the foreign corporate account, because let's say they're an officer or something of that nature, then the individual has to file an FBAR, but you're not aggregating the interests. By the way, we're going to try and take questions as we go along, but in order to cover all of the material that we have to go through today, and there's quite a lot of it, I may have to take a pass on some of these questions, especially if they don't appear to be of general relevance to the entire audience. Okay, so I was going to point out that while you're probably familiar with the Schedule B question, the point here is that if you check the box no when in fact the correct answer is yes, that's filing a false income tax return, and that by itself is a separate penalty, separate felony, without regard to whether there's any understatement of tax on the return. I think everybody knows the FBARs are due on June 30th. They, as I mentioned, they now have to be filed electronically online. The extension of time to file a tax return doesn't extend the time to file the FBAR. You cannot get an extension to file an FBAR. And unlike with income tax returns, where the statute of limitations for the IRS to assess additional tax does not begin to run until a tax return is filed, with FBARs, the IRS has only 6 years from June 30th, the due date of the FBAR, to make a penalty assessment, even though no FBAR was ever filed. Excuse me. There are lots of criminal penalties, and while there are relatively few prosecutions specifically for FBAR violations, I think at last count I saw something like 150 or so. The Department of Justice keeps promising to bring many more. And as I might tell my clients who ask about the probability of prosecution, what I say is, while it's not terribly high, unless you happen to get prosecuted, and then the chances become 100%. So given the draconian penalties and the distinct possibility of jail time for somebody that is prosecuted, in my view, you don't want to be playing this particular lottery on the hope that nobody's going to notice. And then, of course, we have the civil FBAR penalties if a person is not prosecuted. And I might also add that even if a person is prosecuted and goes to jail, they will also be expected to pay civil penalties. So some of my clients ask, well, if I'm willing to go to jail, do I have to pay all this money? The answer is yes. You get to go to jail and pay a bunch of money. So there's several tiers of FBAR penalties, and they are essentially a negligent violation, a willful violation, or if your client can show that they had reasonable cause for failing to file an FBAR, in that situation, there would be absolutely no penalty for the failure to file the FBAR. So the penalty for negligent violation is up to
Dennis, I just lost you. I can't hear you. Did something happen on your end? Dennis, can you hear me? I can't hear you. Does the audience hear me? If you could, someone could just type in whether or not you hear me and Dennis.
Can everybody hear me again?
Yes, now I can hear you,
Okay,
Dennis. Thank
good.
you.
My apologies. Apparently, I muted the presentation. So I think where I was before I rudely interrupted myself was that for the so-called negligent violation, the penalty is up to $10,000 for each violation. And it's the IRS position, which has not really been tested in court, is that if there are multiple accounts, there are multiple clients. So if the client has 3 different bank accounts, then each year that person could be liable for a penalty of up to $30,000. And when you multiply that by the 6-year statute of limitations, we're looking at a potential fine of $180,000, even for a non-willful or negligent violation. Now, there's some new FBAR guidance that just came out within the last couple of weeks, and we're going to be discussing that may reduce the amount of that penalty. Again, we'll talk about it in a bit. I think that, again, we're all familiar with the willful failure to file penalty of the greater, and this is a key point, the greater of $100,000 or 50% of the amount in the account at the time of the violation. And the point here is that if you've got a small account and a willful violation, you can still get hit with a very large number. So let's assume the total balance in the account is $50,000. the penalty could be $100,000 for each year that the account is open, a $600,000 penalty on a $50,000 account.
So Dennis, somebody just wrote in a question and asked whether or not there would be IRS prosecution only on large amounts, or would they actually prosecute a taxpayer who has a small amount, let's say of $25,000?
Well, I think it's unlikely that the IRS is going to prosecute somebody that has a $25,000 account, but what you do have to be careful of is that there are circumstances when, for some reason or another, the person is on the government's radar, perhaps for committing some other violation of the federal laws. Maybe there's a Federal Corrupt Practices Act violation, and the government is interested in the person for something like that, but it finds it perhaps difficult to prove the violation. And if they, find a small foreign account, maybe they, they prosecute the FBAR violation as a proxy for not having enough evidence to prosecute, some other violation. It's the old John Dillinger story. They couldn't get him for bank robbery, but they did manage to get him on tax evasion. So there's a whole bunch of penalties that also arise in these foreign account situations other than FBAR penalties, and these are in addition to the FBAR penalties. I don't want to necessarily go through all of them point by point, but I do want to highlight the Form 3520 penalties. The Form 3520 needs to be filed in a couple of situations. One is if there's a gift of more than $100,000 from a foreign person, and if you don't file that form, the penalty can go up to 25% of the value of the foreign gift. Also, if funds are transferred to a foreign trust or a distribution is received from a foreign trust, those penalties begin at 35% of the amount transferred to or received from the trust. The client doesn't need to be willful. It's only waivable for reasonable cause. I also want to point out that an Australian superannuation fund is a trust, and a 3520 may be required depending upon the type of fund. You have to be very careful with these foreign retirement plans. The clients seem to think that, well, I don't pay tax on it. It's not taxable in the foreign country, therefore I don't need to worry about it over here. And that's not necessarily the case. It varies on a country-by-country basis, and it's only by carefully looking at the various treaties in effect and the underlying plans that you can truly make a decision as to whether or not a Form 3520 is required and whether your client's exposed to any potential penalties. We had a conversation with the IRS hotline about the Australian superannuation plans, and apparently there is some internal guidance out there regarding them, and I've filed a Freedom of Information Act request to get a copy of it, and when I receive it, I will definitely post it on our blog and our website. So that's good reason to pay attention to those things that I keep sending out and that most of you probably get. Okay, so more penalties for the failure to file various forms. No shortage of penalties plus interest. Excuse me. Here the point I want to make is that there's no statute of limitations on the failure to file the various foreign information reporting forms. So that's different than the FBAR situation. So the IRS can assess these penalties going back 10, 15, or 20 years. And unlike with unfiled income tax returns, where the IRS tends not to bother with things more than 6 years old, with these foreign information forms, in the context of audits, I have seen them go back 8, 9, 10 years on these penalties. So this is, you know, something that you really need to watch out for.
There's a question that came in. What are the penalties for failing to file the 8938, and is it being enforced?
I believe that's $10,000.
$10,000. Okay, and I think this is a good time, Dennis, for us to do our polling questions. So according to the certification authorities with the CPAs and enrolled agents, at various times we have to ask a polling question that you need to answer if you're planning to get credit as a CPA or an enrolled agent. So in the question box, if you could just answer this question, and it will be associated with your name, and then you get credit if you have any answer on the 3 polling questions that we're going to have. So do you handle FBAR issues is the question, and just put number 1, that's our first question, in the question box and your answer, and it will be associated with your name. And so we'll be able to monitor that you've actually been on the webinar and listening to us as Dennis is telling you all this information. Okay, Dennis, back to you.
Yeah, by the way, you don't have to have the correct answer to any of these questions. We just need to know you haven't fallen asleep. All right, so I often point out to people that, you know, these FBAR problems and all these foreign problems that we're talking about, it's not just a problem for tax cheats. If you have clients that are immigrants and they have any significant means, you're almost always going to find out that they have foreign accounts. And yeah, so let's keep moving along here. Oh yeah, this last bullet point about the clients who have Canadian retirement accounts, the IRS recently eliminated the requirement to file the Form 8891. However, one is still required to file an FBAR, and one is also still required to list that account on the Form 8938 if one is required to be filed based upon the size and amount of the client's total foreign reportable accounts, the total specified financial assets technically. So, you know, the clients always ask us, how is the IRS going to find out? And there's a variety of different ways. You know, FATCA is now in effect, and interestingly, the Vatican, as of yesterday, announced that it had signed an agreement with the United States that would allow the banks there, the Vatican Bank, and I guess other banks there, to comply with FATCA. So even the Pope's on board. Another big way that the IRS is going to find out about accounts, especially if they're in Switzerland, is through the Swiss bank, what I call the tax amnesty for the Swiss banks. The Swiss banks had until December of 2013 to seek non-prosecution agreements with the Department of Justice. There are 106 banks that signed up, and there is now a June 30th deadline for the Swiss banks to submit the names of all their U.S. clients to the Department of Justice. So that's going to be another way that the IRS is going to find those clients at the Swiss banks. Quite frankly, it's hard to believe that anybody who is either currently has an account at a Swiss bank or who has ever had an account at a Swiss bank hasn't already made a disclosure to the Internal Revenue Service. I'm not going to go into any detail about the specifics of FATCA. I think the important point is that countries around the world continue to sign up to implement FATCA. And a lot of countries that you might not think would be on the bandwagon are. So example, Russia has signed an agreement, China, and Uzbekistan, along with, as I mentioned, the Vatican. So again, I'm not going to go over the details of FATCA, but the important point is that the banks are going to be providing, and have started already providing, a 1099 or the equivalent of a 1099 to the Internal Revenue Service. So there's not a lot of places to hide at this point. And if that wasn't enough, there are whistleblowers that can turn people in, ex-spouses, ex-employees, ex-business partners are at the top of the list. The foreign banks are closing out accounts of U.S. persons who refuse to file the Form W-9 and agree to information reporting to the IRS. The IRS has information from the more than 50,000 taxpayers who are already participating in the OVDP programs. That number was as of January of this year. I haven't seen a more recent number, but it may be out there. I just haven't noticed it. The various plea agreements that some of the banks have entered into, which have involved turning over client information. So I saw, I think it was yesterday, that I believe it was in France, the French authorities raided Deutsche Bank over there. They were looking into various tax violations against the French Revenue Service. I suspect that to the extent that it turns up information about Americans, some of that data will make its way over to the Internal Revenue Service at some point. So against all of this background, the question is, how do we fix it? And Exhibit A is the Offshore Voluntary Disclosure Program, the OVDP. So let's start off by asking the question, who is not eligible? Basically, taxpayers who are already known to the Internal Revenue Service, whether they're under investigation by CI or whether they're under audit. And again, the point here is that it doesn't matter whether or not the audit relates to offshore issues. If there's an audit, it's too late to join the OVDP. Interestingly enough, if a C corporation is being audited, but not the individual shareholder, then based upon our conversations with the OVDP hotline, that individual shareholder would be allowed to participate in OVDP, assuming that the foreign problem hasn't already come out in the audit of the C corporation itself. And also, taxpayers who have a legal source income cannot participate in OVDP or indeed any form of voluntary disclosure.
Dennis, before we get into the history, why don't we do the second polling question here? It's not appearing on the screen, the question. The sole purpose of this is for us to monitor whether or not you're actually listening at 3 points during the webinar. And this is required by the California Board of Accountancy for CPAs and for enrolled agents by the IRS. So the second polling question, to make sure that you're actually there and listening, number 2 is, have you ever worked with the IRS on an OVDP program? So please put number 2, that's the number 2 question, and yes or no, or whatever you want, but we just will have that question, that answer associated with your name, and we will know at that point that you are listening if you are a CPA or an EA. Okay, Dennis, what about the history?
Well, actually, I'm not going to spend much time talking about the history. Just to point out that the program has been in effect since actually, it started up in 2008, and it has ratcheted up over the years from a 20% penalty to a 25% penalty, and finally a 27.5% penalty. And at this point, we have moved all the way to the 2014 program. But the penalties are essentially the same, or the basic penalty structure remains the same, and that's from 2012, and that's 27.5% of the unreported foreign financial accounts, but also even the penalty applies to all of the taxpayers' income-producing offshore holdings, those that are holdings that are related in any way to tax non-compliance. So, for example, if the taxpayer has a apartment in France that they rent out and the income was not reported on the U.S. tax return, then that house is deemed to be, quote, tax non-compliant, and therefore the value of that house is included in calculating the 27.5% OVDP penalty. Even though had an FBAR been timely or properly filed, you would not have had to list that piece of real estate on the FBAR. So when you're deciding whether or not OVDP is appropriate for somebody, one of the considerations is, do they have a lot of non-compliant assets that would not be reportable on an FBAR, and then you need to do a little math to figure out whether or not it makes sense to go into the OVDP. In addition to the 27.5% penalty, the client is going to get hit with the 20% accuracy penalty, and if applicable, in other words, if the tax returns were filed, the original tax returns were filed late, then there's going to be a failure to file penalty and a failure to pay penalty. Of course, in the OVDP, the client can't argue lack of willfulness, and there's no reasonable cause exception. So what are the major changes in the 2014 OVDP? First of all, the penalty has been increased to 50% for taxpayers with financial accounts at what I refer to as bad banks. So these are foreign financial institutions which have been publicly identified as being under investigation or as cooperating with a government investigation. So the IRS has a list of these, and currently that list includes 21 different financial institutions, mostly in Switzerland, but I think a couple in Israel as well. And it is being updated on a regular basis. 2 more banks were added within the last week, and you can expect that many, many more names are going to be added to this list, I would guess shortly after June 30th, because what's happening is, as the banks are finalizing their deferred prosecution agreements with the Department of Justice, remember that 100 or so Swiss banks that have signed up. As those agreements are concluded, the fact that a particular bank has entered into a DPA with the Department of Justice is made public, and at that point, the bank becomes, doesn't become anything. It's included on this list, and the penalty goes from 27.5% to 50% overnight. So if you've got a client at a Swiss bank, they need to get in sooner rather than later for a variety of reasons. And keep in mind that 50% penalty applies not just to the funds at the bad bank, but it infects all of the client's accounts. So the penalty jumps to 50% of the total penalty base, no matter where the assets are located.
And we have another
Some other changes are that
Dennis,
we
had another question that just came in regarding safety deposit boxes. How are they handled?
A safe deposit box is not a financial account.
Okay, let's see, foreign account closed and cash deposit into a safety box at the foreign bank, so it's not included.
Well, all right, let's go back a step. If it started out as a financial account, then you still have the requirement. You still should have been filing FBARs while the account was open. Now, once it's closed, the year after it's closed, then there is no foreign financial account, and you no longer have a requirement to file an FBAR. So I'm not sure if I've answered the question or not, but
so
I hope
the question is, if the money comes out of the account and goes into the safety deposit box, and it doesn't need an FBAR.
Well, it doesn't need an FBAR in the future, but it needed an FBAR in the past. And therefore, I think that somebody who had a safe deposit box, who had an account at, let's say, UBS, which is one of the bad banks, they had an account at UBS, and they took the money out of that account, and they put it into a safe deposit box. My suspicion is that the 50% penalty would still be applicable. Okay, some other changes. We're going to talk about FAQ 17 and 18 that have been eliminated or revised, the document submission requirements that have changed, and I want to point out that the so-called reduced penalty structure under former FAQs 52 and 53 have been eliminated. These were the 5% penalties, for example, for certain foreign residents, and for persons who were unaware they were U.S. citizens. There were several categories of these individuals, and the idea is that most of them, although I have to tell you, not necessarily all of them, are going to be covered under the Streamlined program, which we're going to talk about in a moment or two. So FAQ 17 has been superseded. They now have a new separate delinquent FBAR submission procedure, but it's very similar to the old FAQ 17. FAQ 18, on the other hand, has been eliminated, and that is, in my view, very bad news. So under the old FAQ 18, if you had a taxpayer who didn't file 5471s or any of the other foreign information reporting forms, as long as all their taxable income had been reported, they could just go ahead, file delinquent information returns, and there wouldn't be any penalty. The IRS has done away with that, and now you still submit the delinquent international forms, but you have to include a statement of reasonable cause as to why the returns weren't filed in the past. And if the IRS doesn't agree with your reasonable cause statement, then the client will still be hit with the with the penalties. And the IRS makes very clear that that this is a distinction. If you look at FAQ number 1, this is not FAQ number 1 to the OVDPs, but it's a separate FAQ specifically linked to the Delinquent International Information Return Submission Procedure. And by the way, that's one of the things that's confusing about the 2014 programs, is that the IRS has separated out the FAQs so that if you want to figure out what's going on, you not only have to look at the FAQs for the OVDP or for the OVDP program, but also the separate FAQs for each of the other programs, like the Streamlined, like the Delinquent International Information Return Submission Procedures, like the transitional procedures. So it makes it a little more challenging. So in terms of documentation changes under the 2014 program, FAQ 25 contains a long list of documents that need to be submitted, and you just need to refer to that to get the complete list. No point in going over it today. The key thing that's changed and is of most interest to clients is that now they need to submit a check for the full amount of the taxes, interest, and the 27.5% and 20% penalties at the time the full disclosure submission is sent in to CI. Under the old procedures, the client didn't need to send a check for the penalties until the time the closing agreement was being signed, which could be as a year or more after the submission had been made. So the clients need to be prepared for this relatively early payment of the tax and the penalties. So there's a new streamlined compliance procedure that is now effective. The IRS completely revamped the old streamlined program because it was, frankly, way too restrictive and too complicated. Anybody who applied under the old program has been automatically moved over into the new program. So if your client applied previously, nothing else needs to be done unless and until you're contacted by the Internal Revenue Service. The streamlined compliance procedure is actually two different procedures. There's the streamlined domestic offshore procedure and the streamlined foreign offshore procedure with the usual set of acronyms associated.
Why don't we ask our last polling question here, Dennis? And
okay.
That is, do you know the difference between an SDOP and an SFOP? And all we need is an answer from you. Please put 3, the number 3, and your answer, whatever it may be, if you're a CPA or an EA and you are seeking credit, so that we're monitoring that you're listening at this point in the webinar. Thank you.
Okay, so generally speaking, in order to get into the streamlined program, either streamlined program, the taxpayer must certify under penalties of perjury that their failure to report foreign income and the failure to file FBARs and the information returns was all non-willful. Taxpayers who are participating in the OVDP already are not eligible for the streamlined procedure. Once you go into OVDP, you can't switch. There's a transitional program offering a 5% penalty, but slightly different, not full streamlined treatment for individuals who were already in OVDP at the point when the IRS came out with the new updated streamlined compliance procedure. And you're going to have to look at the FAQs for details of that. A prior quiet disclosure doesn't prevent a streamlined doesn't prevent somebody from entering the streamlined procedure. And taxpayers at the so-called bad banks are not prohibited from entering the Streamlined procedures. In the Streamlined program, the client is going to submit only 3 years of amended tax returns, unlike OVDP where you're doing 8 years. 6 years of FBARs need to be filed. You need the non-willful certification signed under penalty of perjury. Under the Streamlined, there's no accuracy penalty, no late filing penalty, no late payment penalties. The IRS likes to point out that the Streamlined procedure is just that, a procedure and not a program. And by making that distinction, they say that there's going to be, and there has been, no acknowledgement of acceptance of the Streamlined filing. There's no Form 906 closing agreement. And perhaps most importantly, there's no protection whatsoever from criminal prosecution. What are the differences between SDOP and SFOP? Remember, the SFOP is the foreign program, SDOP is the domestic program. So all the penalties are waived under the SFOP. In the SDOP, there's a 5% miscellaneous penalty on the highest financial account balance during the prior 6-year period. And unlike the OVDP, the penalty base does not include the non-financial accounts. So that's a significant difference. In order to file under SFOP, the taxpayer must meet certain non-residency requirements. As far as SDOP filers go, they must have timely filed the previous 3 years of income tax returns if a return was required. So if they haven't filed returns but they were required to, then in that situation they're not going to be eligible to enter the Streamlined program. And some tax practitioners have suggested that if a taxpayer files late tax returns, he can meet the requirement of having filed tax returns as specified in the SDOP and immediately submit amended returns under Streamlined. The IRS has said in various public forums and seminars that this is not a backdoor into Streamlined and that you cannot qualify for SDOP if you haven't filed the required returns on a timely basis. Who's a non-resident or SFOP that would be entitled to the zero penalty? Basically, that person has to show that in one or more of the most recent 3 years for which the U.S. tax return due date has passed, the taxpayer did not have a U.S. abode and the taxpayer was physically outside the U.S. for at least 330 days. So in one, the taxpayer only has to qualify in one of the years. Not going to spend a bunch of time on the definition of abode. You need to look at the statute and the regulation, but usually this is not a problem who is somebody out of the country for 330 days, but it could conceivably come up with someone who's working temporarily overseas and leaves his family behind in the U.S. And so I would take a much closer look at this if you've got a client in that situation. Non-willfulness. Non-willful conduct for the purposes of the new Streamlined program is conduct that is due to negligence, inadvertence, or mistake, or conduct that is a result of a good faith misunderstanding of the requirements of the law, direct quote. The IRM says that willfulness is a voluntary, intentional violation of a known legal duty. One of the points that's rather unclear is, will willful blindness negate non-willful conduct? So what's willful blindness? This is a situation where a person is treated as if their conduct was willful, even though they didn't know about the FBAR reporting requirements, if they took steps to avoid learning about the FBAR requirements. Now, generally speaking, the requirement for willful blindness is fairly high, at least in my view and in the views of a lot of other people. But there have been a couple of courts who have, again in my view, incorrectly found willful blindness existed based upon the failure to review Schedule B of the tax return. And it's fairly controversial, but it is a potential issue that lurks out there. So what are the downsides of the streamlined compliance procedure? Most importantly, it doesn't provide protection from the risk of criminal prosecution. And also, if you make a submission under Streamlined and the IRS determines that your conduct was willful or not non-willful, then you get kicked out of the Streamlined procedure, and you cannot at that point elect to enter the OVDP. You're right smack dab in the middle of an audit and exposed to the full panoply of various penalties. Some alternatives to entering the OVDP include filing a quiet disclosure, fixing it on a go-forward basis. You know, you can stick your head in the sand and do nothing. And you know, there are definitely risks and rewards to all of this, and all of this needs to be balanced when the client is making a decision as to whether or not to go into OVDP or Streamlined. That's something that has to be discussed with a great deal of care with the client. A comment regarding quiet disclosures. Filing amended returns and amended FBARs by themselves is not a true quiet disclosure. There's a lot of confusion about that. A lot of times people say, oh, I did a quiet disclosure, I filed the amended returns. You need to take a look at the Internal Revenue Manual to see what constitutes a voluntary disclosure, and you'll note that, among other things, it requires flagging the returns by including a letter indicating a willingness to cooperate with the Internal Revenue Service. And even though a quiet disclosure may insulate against criminal prosecution, A, there are no guarantees with that, and B, if you just send in amended returns, you don't even meet the terms of the IRS's voluntary disclosure practice. So there's very little protection by simply filing amended returns and amended FBARs. I'm just going to proceed fairly quickly because we're starting to run out of time here. I think a couple of key points are the tax court doesn't have jurisdiction over the penalties. They're not dischargeable in bankruptcy. Basically, in order to enforce the penalty, the IRS must bring suit in district court and prove that the penalties apply. The penalties cannot be collected through IRS levies or liens, even after a judgment has been entered against the taxpayer. I think this is a good point to bring up the recently released new FBAR guidance. It's effective for all currently open cases, and I discuss it here because it doesn't apply to OVDP or Streamlined. It's only the people outside of the various programs. It places limits on the amount of the maximum willful penalty. So the IRS says in the guidance they will never impose a penalty more than 100% of the highest aggregate balance for all years, and that in most cases the penalty will be limited to 50%. So mostly you're going to have a 150% penalty, but the IRS says that facts and circumstances could either reduce the penalty below 50% or send it over 50%, but never over 100%. The FBAR guidance also indicates that the non-willful penalty will generally be limited to one $10,000 penalty per year, no matter how many accounts they are. However, they reserve the right to include to charge a penalty either larger or smaller than $10,000 per year, but not exceeding 50% of the highest aggregate balance over all the years. By the way, if you have somewhat smaller accounts for your client and the accounts are under $250,000, you definitely want to take a look at the mitigation guidelines set forth in the Internal Revenue Manual, because you'll find that in some cases the penalties will work out significantly lower than $10,000 per account or even $10,000 per year. Another important point about the FBAR guidance is that it makes clear that group managers, not the FBAR coordinators, make the final decision as to the type and amount of the penalties. It's no longer necessary for them to get IRS counsel review of the non-imposition of a willfulness penalty. It's only if the group manager decides to impose the willfulness penalty that counsel will need to review that decision. The guidance provides a checklist of items that need to go into the FBAR case file, and it mentions a summary memo that's supposed to be prepared by the examiner explaining the reasons for the FBAR violation, and very importantly, that memo is supposed to be supplied to the taxpayer. So you want to be looking for that in case it hasn't been supplied. Just briefly, I want to talk about some potential malpractice issues. You need to take a look at Circular 230. And I want to focus here for a second on the second bullet point. If you have a client, even if they don't tell you about a foreign account, if, for example, you know that they're doing business overseas, and it would seem likely that they don't have a foreign account, that they would have a foreign account, you need to challenge the client on that and get an explanation. Even if they say, no, I don't have a foreign account, but they have, let's say they have substantial overseas business, you need to ask some questions. Well, how do you get paid by those overseas clients? You don't keep a bank account over there. What if they're paying you in Korean won? How do you get that into your U.S. account? Yes, it could be wire transferred here. Yes, the client could be getting paid in U.S. dollars directly, but you need to ask some follow-up questions. You can't simply rely on the representations if those representations don't seem to ring true. Some suggestions you can read later that I suggest for accountants preparing tax returns. And then I came across this recently. I want to talk here about, what the CPAs and enrolled agents need to consider if you discover that your client has an undisclosed account. I'll point out to you that the Texas CPA Society highly recommends involving an attorney before a CPA prepares an amended return that discloses a previously unfiled FBAR or Form 8938, or where there are issues about undisclosed, foreign income. And while I don't know if anybody on the line is from Texas, you can be sure that if something goes wrong two things are going to happen. One is that some plaintiff's attorney is going to sue you for malpractice, and he's going to be waiving this pronouncement from the Texas CPA Society in your face as being a, quote, best practice. The other thing that's going to happen is if something goes wrong, you're going to be interviewed by the IRS, at which point you may need to consider hiring your own counsel. The tax return preparer is usually one of the first persons the IRS contacts in a criminal investigation. As a tax preparer, you need to consider the potential conflicts of interest in representing a client and making a disclosure. So could the client claim reliance on you, the preparer, for not having sufficiently asked him about the existence of the foreign accounts in the past? That's a considerable problem. Some other issues are that the filing of a 1040X or a late FBAR is an admission and a waiver of Fifth Amendment privilege, not only as to the information contained in the document, but as to all the communications regarding the same subject matter. And the filing of these FBARs and amended returns is no protection against criminal prosecution. You, as a CPA or an enrolled agent, you may be aware that there's something called a federally authorized practitioner privilege that protects your communications with the taxpayer and is somewhat similar to the attorney-client privilege. One of the problems, though, is that this federally authorized practitioner privilege may not apply to FBAR issues because this privilege only covers, quote, tax advice. And the filing of an FBAR is covered under the Bank Secrecy Act, not Title 26. So query, is this the type of advice that would be covered by the FPP? And also importantly, this practitioner privilege doesn't apply to criminal matters, so if the case goes bad, then the conversations that you've had with the client are not going to be privileged. So I think that wraps it up. We made it to the end of our slides with only going a minute or two over, a new first for me personally, and hope you enjoyed the seminar. And we'll be posting a copy of the outline on the website. I think you'll be getting an email. Barbara, did you have anything we needed to add on?
Yes. Thank you, Dennis, and thank you for everyone for attending. Some of the questions were very specific, Dennis, and hopefully you'll be answering them later. But we did have others, but unfortunately we're running out of time. So for continuing education, if you're an attorney, an enrolled agent, or a CPA, please email Giovanna, and her email is on the screen here. And she will send you a certificate and an evaluation. Again, MCLE is pending, but no doubt we will get that. The slides and the recording, as Dennis mentioned, will be on the Brager website. Dennis will also be speaking at the 2015 IRS Nationwide Tax Forum on a primer on international tax forms on August 11th in San Diego. So please contact him with any questions about this very complicated topic. Thank you, everyone.